You're going to jail right now. I'm going to have to argue about everything from who she is to what the charge is. It'd be easier to just put on the prelim. You are playing games, and first of all, you don't.
I'm trying to advance to
all right,
what I'm
stop.
here.
You don't interrupt the judge.
Please.
No, you're going to jail.
I
know you don't wish to go to jail, but you certainly have earned it. The title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
Hold on. The judge just said someone is going to jail before the hearing has even started. That's already a huge red flag. In court, interrupting a judge or refusing to follow basic procedure can escalate things fast. But what makes this case even more unusual is the legal strategy the defendant is about to use, a strategy courts across the country see all the time, and it almost never ends well.
I'm here as a sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime an autograph is to be done in a certain manner that I have here, or it's forgery. Could you do this for the judge, please? That's my name. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan beneficiary with quick bail bonds.
I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair.
Listen closely to what she's saying here. This language, free woman on the land, special appearance, beneficiary of a name, comes from a belief system often called the sovereign citizen movement. The idea is that a person can avoid court authority by rejecting the legal version of their name or identity. The problem? Courts have rejected these arguments for decades. Judges usually shut this down quickly because legally, it simply doesn't work.
I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, and hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her I've kind of hatched this plan.
He's offering to reduce the driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim.
Now, this is a critical turning point. The prosecutor is actually offering a very generous plea deal. The felony charge, resisting and obstructing an officer, could mean serious consequences. But the offer here would reduce it to a misdemeanor and potentially dismiss other charges entirely. In legal terms, this is the kind of offer many defendants hope for. The big question now is whether she understands the opportunity in front of her.
I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the...
It's a benefit. And
no, before that, about the license.
He's dismissing it, and it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it, and that's a benefit. He is offering to reduce the felony charge to a misdemeanor, and that's attempted resisting obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's just put on a prelim.
I'm serious.
You are playing games, and first of all, you don't...
I'm trying to advance to
all right,
what I'm
stop.
here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth. So.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So, do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office.
To do what?
To if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do you want me to appoint an attorney for you, or would you like to represent yourself?
So, may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case.
And my next question is, I know that the Constitution grants the court two types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these two jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution, and I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed, and I would like it in writing, please.
Thank you. It's not civil procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan and have just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct.
I'm competent and I am confident. Okay?
All right.
So
the next question is, are you willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to appear for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure under admiralty or military tribunal venue.
Stop. We went through this before.
I know.
This is not civil procedure.
The Sixth Amendment grants me the right to know the jurisdiction being applied.
And I told you what it was.
And it gives you the duty.
All right, stop.
And here's where the tension explodes. The judge is clearly running out of patience. From the court's perspective, this isn't a debate about philosophy or constitutional theory. It's a criminal proceeding under state law. When a defendant keeps repeating arguments that courts have already rejected, judges often see it as wasting time or refusing to follow procedure. And that can lead to serious consequences very quickly.
If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, please.
Please.
We're going to talk about this tomorrow at 3 o'clock. I find that you're in contempt. You're
I do
going
not
to
wish to
jail
be
right
held in
now,
contempt,
and we
sir.
will, well, you have been.
I'm simply
This matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward with
jail.
this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. And you will be more respectful to the court.
I can provide the citations.
You will not interrupt the court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can go with the officer. I don't want to argue about it. Take her out of here. We will address this tomorrow at 3 o'clock.
Stand up and put your hand
No,
I can't get her aspects she has there.
they'll get them for you. You can give all the paperwork to him.
Thank you.
Mr. Marvin, I don't know what you've got tomorrow at 3 o'clock, and I don't know what I have, but we'll take another shot at this tomorrow.
Justice takes time.
You just misunderstood.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
That's it, then it's court over.
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that. But,
Well, I told her to stop, and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's going to contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock, and to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admin.
Please have that record still, or that chart, that option still, if I talk to Mr. Marvin.
Yeah, I guess so. Well, you can't represent her as a lawyer,
I know,
but he could, yeah, Mr. Marvin wants this to be over with.
I do too.
All right.
Thank you.
Ms. Keenan had previously indicated she did not wish to have an attorney, and there was no attorney on her behalf at that time. Prosecutor David Marvin was here yesterday, and there was one or more police officers that were here yesterday prepared to testify. We didn't get very far. We started to go through the particulars, but Mr. Marvin made a plea offer. I want to repeat that, Ms. Keenan. He stopped in this morning and confirmed to me that his plea offer was still open to dismiss the felony charge and the driving suspended charge for the plea to attempting to resist or obstruct a police officer. We were talking with Ms. Keenan yesterday. I found that she was in contempt and ordered that she go to jail, and she did, and we're here today. We were trying to establish whether she wanted any legal assistance in this matter. So, Ms. Keenan, you're the same person that you were yesterday with the same reservations and concerns. Is that correct?
Thank you. I have some things, like proof that the license shouldn't have been suspended, and they did reinstate them in Indiana.
All right. Well, he's willing to dismiss that charge.
I think that's why, because I showed it to him.
All right. Well, maybe so. He said you and he had several discussions. So let's see if we can get to square one here. Do you want an attorney to assist you in this matter? I can appoint one, and we can set it for further hearing. I don't want to force one on you, but I do think you could benefit from having counsel. It was clear you didn't understand the difference between a criminal case and a civil case, and you contempted yourself into a day in jail. I won't be offended if you tell me that you want to have an attorney, in which case I would set this matter for further proceeding out 2 weeks.
So if I choose to get an attorney, I have 2 weeks, and then nothing else will be brought up today. Because
Correct. Now, you could enter the plea to the misdemeanor offer that Mr. Marvin made.
This is the moment everything collapses. The judge warns her multiple times to stop interrupting. And when she continues, the court holds her in contempt of court. Contempt is one of the few powers a judge can use instantly to restore order in a courtroom. It means jail time right now, not later. The lesson here is simple. Even if you strongly disagree with the court, ignoring a judge's direct order is one of the fastest ways to end up behind bars.
Today. But I do think you could benefit from having an attorney to assist you with this, in which case I would continue it to the 5th of July. That's 2 weeks from today in the afternoon. Usually it'd be on a Tuesday, but that's a holiday. It would be 1 o'clock on July 5th.
am I going to be still having to stay at the county jail and wait till?
Well, let's talk about that. No, you posted a $10,000 cash or surety bond. However, you've not agreed to be fingerprinted. So as soon as you agree to be fingerprinted, you can be released from jail. Otherwise, you're going to sit there for 2 weeks. All right. Would you like me to appoint an attorney for you?
Yes, if you appoint an attorney,
Go
they're
ahead.
defense attorneys.
Yes.
Okay.
Here's your son. All right, I'm going to appoint an attorney, which I think you could benefit from. I guess you can always say later, I don't want one, but it looks like you have an opportunity to consult with one.
Thank you.
But you're not to be released until you complied with the booking process, including photo and fingerprints.
Excuse me.
Yes, sir.
Today,
Yes, ma'am.
I think it was today, or maybe because I slept a lot, so anyway, they booked me and took my picture.
All right, well, the
Is that
picture's
good
done.
enough?
That's good enough, but you have to
That's
agree
good
to the fingerprints.
Oh, I still have to do
Yes.
the fingerprints?
And you can decide whether you want to do it. If you don't, that's up to
Well, I'm
you.
going to do it.
All right.
Because I appreciate your offer. Thank you.
Fast forward the next day, and the tone is completely different. After spending time in jail, the defendant finally agrees to accept a court-appointed attorney. This is actually a crucial shift. A defense lawyer understands the rules of criminal procedure, how plea deals work, and how to protect a client's rights without clashing with the court. And honestly, this moment shows one of the biggest truths about the justice system. Knowing the law and having someone who practices it can make all the difference